So next one is the breach of contract. So the discharge of contract is over. Next one is breach of contract. So what is called breach of contract? So breach of contract and its remedies in the sense, in discharge of contract means what are all the way the contract will comes to end. That is called discharge of contract. Whereas breach of contract in the sense, what are the remedies are available for the affected party if there is any kind of a breach in the contract. Breach means cancellation. If there is any cancellation of the contract from both the parties or either one party, what kind of remedies are available to them? We are going to study that topic in this. So types of remedies: suit for rescission, suit for damages, suit upon quantum merit, suit for specific performance, suit for an injunction. So first of all, we should know the meaning of breach of contract. So what is called breach of contract? Breach of contract means failure or refusal by both the parties to perform their respective promise. That is called breach of contract. Parties to a contract are expected to perform their respective promise. If a party break its obligation or if they are not going to perform the contract, that is called breach of contract. If that kind of a breach occur, what are the remedies are available to them? What kind of compensation is available to them? That one only we are going to discuss in this topic. What do you mean by remedy? First of all, a legal remedy is a court order that seeks to uphold the person's right or to redress a breach of the law. When one party breach a contract, the other party may ask a court to provide a remedy for the breach. The court may order the breaching party to pay a money or non-breaching party. So when two parties enter in a contract, if any one party are cancelling the respective contract or without giving proper notice, or when in such a way that they are they are not completing the contract. In this situation, what kind of a remedies or compensation available to the another party? That is only we are going to discuss now. So breach of contract occurs when any party to the contract failed to perform his part of the contract. Any party to the contract make it's impossible for the other party to perform his obligation. Breach of contract may occur in two ways: anticipatory breach of contract and actual breach of contract. So what is called anticipatory breach of contract? A party declares his intention of not performing his respective promise before the performance. That is called anticipatory. Whereas actual in the sense, on the due date of performance or during the course of performance. So anticipatory, as I told you, anticipatory breach of occurs when a demonstrate his intention to break a contract. Rajesh agreed to marry Shanta. Before the date of marriage, Rajesh heard that Shanta going to marry Sudarman. So what do you mean with this? When the party show his intention towards another party that he's not like the contract, that means whatever it is. What is called anticipatory? When there is a two person in a contract, any one party show his intention not to perform the contract. That is called anticipatory. Actual in the sense, based on their performance, you could be able to comes to know to the conclusion that he or she is not willing to perform the contract. Remedies for breach of contract. Under that, there are 5 types: suit for rescission, suit for damages, suit for quantum merit, suit for specific performance, suit for injunction. Suit for rescission. So what is called rescission? Rescission means cancellation. So in such case, if one party has broken his contractual relation, the other party may treat the breach as a discharge or refuse to perform his part of the performance. Thus, in case of rescission of a contract, the aggrieved party or injured party is discharged from all its obligation of the contract. By example, cancelling the contract by mutual understanding. So what do you mean by this? When two parties enter in a contract, if any one party is not willing to perform its respective promise, mutually they can cancel the contract. Example, A contract to supply 10 kgs of leaves for 8,000 on June 15th. If A does not supply on a tea leaves on a particular appointed day, B no need to pay for the price. B may treat the contract as resigned and may sit quietly at home. B may also file a suit for rescission or claim the damages. A promised B to supply 10 bags of cement on a certain day. Another example. B agreed to pay a price for the after recipient of the goods, but A does not deliver the goods in this case. So that is called suit for rescission. When one party is cancelling his respective promise, the another party also no need to perform his respective promise. But there is a condition applied. If without sometime, if one party cancelling the contract without intimating to the another party may suit against the particular person. Suit for damages. The amount of compensation awarded to the aggrieved party for the breach of contract. Damages or monetary compensation allowed to the injured party for the loss or injury suffered by him or less result of the breach of contract. The fundamental principle underlying the damages is not punishment, but not to compensate agreement fee particular contract. So what is that damages in the sense? When two parties enter in a contract, if any one party is not performing the promise, the another party may face some damages. Okay. So for that, he has to compensate. So that reasons, for that reason, there are four types of damages are categorized here. Ordinary damages, special damages, exemplary damages, nominal damages. So these are all the types of damages under suit for damages. Okay. So ordinary damages, what is called ordinary damages? Damages that arise in the ordinary course event from the breach of contract. When one person is not performing his respective promise, the another person may face some losses due to the differentiate market price. That is called ordinary damages. Do you understand? So ordinary damages in the sense when two parties, for example, see, I have entered in a contract. A contract to sell delivery to deliver B 50 bags of rice at 1,050 rupees per bag. The price to be paid at the time of delivery. The price of the rice is raised rupees 1,500 per bag and A refused to sell the rice. B can claim the damages at the rate of 50 per bag. So what do you mean by this? For example, I'm a customer. I went to one grocery shop. I asked the particular grocery shop person, the seller, to deliver 5 kgs of 25 kgs of rice. So he said 25 kgs of rice cost is in today's rate, it is a 1,450. I said, okay, you just do deliver it. Once you deliver it, I will pay you money. Okay. But he has not delivered the goods. Next day, he bought the goods. Next day, he brought the goods to my home and he was asking 1,500 per bag. Then I was asking him, yesterday I came to a shop. That time the rice cost, it was 1,450 only. Even I told you clearly that I want you to deliver the goods in today itself. But it is a seller mistake or seller, by carelessness, he has not, maybe due to some commitment, he has not in a position to fulfill the order. Okay. So next day he is giving a product, but that time the cost is increased, 50 rupees. In this case, who can claim the damages? The seller or buyer? So the seller or buyer? The buyer can claim the damages. Okay, he no need to pay 50 rupees extra. Why? Because before the day of price increase itself, he has clearly given an order. But the billing also has done, but amount only yet to given to the seller. So the billing has done on the day. That time, what was the market price? That is only to be considered, even though the product is delivered on the next day. Okay, even though the product is delivered on next day, that time if the cost is high, also no issues. Okay, that time the seller only he has to bear the losses. Special damages. Sometimes the special damages are those resulting from a breach of contract on some special circumstance. It must have been known to both the parties. Unlike ordinary damages, special damages cannot be claimed as matter right. Example, There was a book exhibition at Madurai on 10th June. A publisher handed over the books to the carrier and informed them that the book must reach Madurai on or before the date of exhibition. But the carrier delivered the books after the exhibition. The publisher is entitled to claim the compensation special damages. What is called special damages? Special damages in the sense when any one party suffer a loss, suffer more, or faces some losses due to the negligence or due to the refusal of one party's performance or delay of performance. That is called special damages. Do you understand? So again, I'm explaining this exhibition as the exhibition example. So there is an exhibition in Madurai. So I'm the publisher. I'm handovering the goods to one courier company. I have given a clear instruction that there is an exhibition in Madurai on 10th. So you have to deliver the books on or before the date. But he has not done. He has delivered the goods in a delayed manner. That means in Madurai, the book reached on 12th only. Okay, now no use of receiving a book. Why? Because the purpose is for exhibition only. I have transferred the book and I have given a clear instruction to you. But due to the negligence of, due to the carelessness of the particular courier person, I'm facing the loss. So in this situation, what I will do, I can sue the case against the particular courier person. That is called special damages. So what is called special damages? Special damages means when one person may faces some losses due to some other person's negligence or some other person's not performance of activity or whatever it is. That is called special performance. Whereas ordinary damages in the sense, if there is any, if due to one person's delay performance, due to one person's negligence, if other party faces some part of losses, some small part of losses, then the other party only has to bear it up. Nominal damages. Nominal means namesake. Ordinal means only the market differentiation price has to be given as a compensation under the ordinary damages. Whereas under the special damages, fully they have to compensate. Whereas under the nominal damages, this is only for namesake. Okay, this is only for namesake. Even though one party is not performing his respective promise, the other party will not face that much loss, because I will give you some examples. See here, nominal damages are those which are awarded only for namesake, where the injured party has not in fact suffered by any loss. Example, where in a contract of sale of goods, if the contract price or market price is almost the same at the date of breach of contract, and the agreed parties entitled only to the nominal damages. Example, D, contract to purchase a Vespa scooter from a dealer E, but he refused to purchase the scooter. However, the demand for Vespa scooter exceeded the supply. The scooter dealer could not sell the scooter agreed to purchase without any loss of profit. So what do you mean with this? I will give some other easy example. For example, I am having one bike showroom. One customer visited my showroom. My client also, my showroom client, he has received a particular customer. He treated, he was asking all the requirements of the particular customer. According to his requirement, he has shown one bike which meet up the requirement of the particular customer. Almost he has spent 2 hours of time, all the things. Then my client asked the particular customer, sir, shall we do the registration of a bike? That means, shall we do the billing? Then he said, after 2 hours spending of a time, the particular customer is saying, okay, sir, let me go and talk with my parents and I'll get back to you. Okay, same kind of activity will occur everywhere in all the shop, in all the malls, because we could not force any kind of customers to buy the product. It is up to them. That is their right. They have a right to choose. We should not force them to choose any kind of a product, right? So in this case, when two parties about to enter in a contract, when one party is not performing this, that the customer has given a promise, sir, tomorrow definitely I will come and buy the bike. Then the client again and again saying, sir, at least pay some down payment, maybe the 5,000, 10,000. Tomorrow you can come and pay the remaining amount, or you can take it in a due mode, EMI mode, or whatever it is. Then he said, the customer said, yes, sir, please wait for one day. Let me go and talk with my parents, and I'll come along with him and I will buy the bike. But the next day, he has not at all turned up. In this case, the particular bike showroom, they cannot put a case against the customer. This is just a small nominal damages. Okay. So here, yeah, of course, to us, time is waste. But if one customer goes, the another customers come, right? So automatically here, there is no that much damages occur to the seller. That is called nominal damages. Exemplary damages. This is an extraordinary case. So what is called exemplary damages in the sense? The damages are intended to show the court strong disapproval of the conduct of the defendant once sued at a court in a committing of wrong. These damages are punishment in the nature which is awarded with a view to punish guilty party, where a banker refused to honor the check. So this is an extraordinary case when the banker is refused to honor the check. For example, I am handovering the check to the banker to withdraw money. The check carries check is worth of around 1 lakh. I'm giving the check to the banker. Banker is verifying the check period, everything, validity period, everything is having validity. Okay, but he's refusing to give a money, refusing or honoring my check without any proper information. And again, I'm asking the clarity from the banker why you are not giving money to the check which I'm depositing. But there is no any clarity from his side. In this case, what I will do, I will suit a case against the banker. That is called exemplary damages. When two parties in a contract, any one party is not performing the respective promise, because of that, the another party is, suffer a lot emotionally, okay, physically and emotionally. Then he can or she can file a case against the person. Okay, same one. Rules regarding the damages. The damages must be naturally arises. The aggrieved party must have suffered suffered damages to compensate the loss caused by a party, but not to punish by mutual consent of both the parties. So some example I have given already here. Suit upon quantum merit. So what is called suit upon quantum merit? Quantum merit means as much as earned. What is called as much earned? Whatever, when two parties enter in a contract, one party started to perform the respective promise based on the promise given by the another party. Okay, but after some period, the main party, the person who has given an order, is refusing to accept or canceling the order. Because of that, the other party suffer. What he can do, he can claim an amount whatever work he has performed so far. That is called as much as earned. For example, I will give you. In this case, a firm printer agreed to print 100 copies of book for B, A firm of publisher. Okay, so A in case of a firm of printer agreed to print. B is a customer. B is a customer. B has given an order to the printer A to print 1,000 volumes of book. He agreed. He has taken some advance also. The A printer started to print the book. Almost 500 books got printed. That time he is receiving a call from the customer B, and B saying that please stop printing the book. I am canceling this order. I am canceling this order. Why? Because there is a mistake in this book. I need to reframe it. It needs some time. So in this case, what will happen? The printer can file a suit against the particular person. Yeah, printer can file a suit against the particular customer. Why? Because by believing the word of the customer, after receiving the advance only, he has started to perform his work. Okay, so without any kind of a proper intimation, in case if the customer is canceling it, what will happen? He will gain a compensation for the whatever work he has done. That means if he has printed a 500 book, in the sense, at least the customer, he has to bear the 500 book publication and printing cost. Printing cost he has to bear. Okay, that is called suit upon quantum merit, as much as in. One more example I will give you. Okay, I am a building contractor. I'm a building contractor. One customer has come. They were entering in a contract with me. So for ground floor and first floor, we are going to build up. Okay, for that, I have given my quotation. All the things over. There's with help of bank loan only we are doing all the things. So partially he will be releasing the amount. With help of that, I entered in a contract. I started to build my building. I started to build. Okay, I'm a builder. Started to build a particular construction. That basement got over. Almost the pillars, everything completed. The first floor also completed. That time I got a call from the customer saying that, sorry, I'm just canceling this building contract. I'm canceling the building contract. I don't want to further, I don't want to continue this building construction further, in the sense. Just like that, I can't leave. Why? Because I almost have done my work almost. Okay. So what I will do, whatever work I have completed, so for that I will put the estimation. Then I will collect a compensation or money from the particular person. That is called quantum merit, as much as earned. Suit for quantum merit. It means as much as earned, I told you. Next one, suit for specific performance. So some example is there, suit for specific performance. So suit for specific performance, in the sense, when the when the contract is created based on some specific performance. That means if the contract is created based on some skill, based on some skill of a particular human, then if the contract is, if the parties in a contract is refusing to do so in future, then the another party can suit him for the performance. For example, see here, A agreed to buy B to sell a picture on 2 China base. A may compel B to specially to perform the contract. For this, no standard for ascertaining the actual damages which would be caused by non-performance. Okay, so for example, I'm a painter. Okay, I'm a painter. One customer got very much impressed on my painting. So what happened? She has visited and she was entering a contract. She got an approval from me, and then even I entered in a contract with her to do painting for her home. She knows very well I am a very good painter. But what happened on the after giving assurance everything, due to my personal reasons, I could not able to do so. So I'm appointing some other person to do this work. Okay, in such time, that time she is refusing that. That particular customer is refusing and suit against me. Why? Because sometimes she may relieve me. So sometimes she may give back. She may give up this contract, but sometimes she can suit against me. Why? Because since this contract is created based on the some specific performance. What do you mean specific performance? Based on skills. There might be plenty of painters are available, but the skill of mine might be differ from others, right? So in such situation, either I need to complete the contract or else I need to pay a compensation for the particular customer. That is called suit for specific performance. So this is one of the case study, Coral versus Ambigate Railway Company. So what is that? Coral? Coral is a furniture, wood furniture company. So what they will do, they will not manufacture all the furniture just like that. Once they get the order, then only they will start to involve for manufacturing process. So this Ambigate Railway Company, what they have done, they have given an order to the Coral company. By receiving an advance, they have started to work. They have given an order for making a compartment, railway compartment, the seat and all is there, right? Wood the seat. So for that, they have given a order. But Coral company also, they started to perform this. They started to involve in a manufacturing process. Almost the work almost done, but Ambigate Railway Company suddenly they were cancelling this order. So in this case, what happened? The car company, they sued against the ambiguous railway company. So this case will come under quantum merit. That means what? Suit for quantum merit. Okay. Suit for injection. So what is called suit for injection? Suit for injection in the sense preventing somebody else to perform something. That is called injection. Preventing. Stay order. We can say stay order also, right? So what is called injection in the sense is an order of the court or directing the party who commit with a breach of contract either to do or not to do something. It is usually given in a case of anticipatory breach of contract. For example, Vijay agreed to act only for Sun Direction movies for 1 year. So Vijay might be anything, anybody else. Okay. So there is one actor, not okay. So he agreed to act only for Sun Direction movie for 1 year. During this year, he has contracted actor. He has also entered a contract with the Vision Production. Okay. So in this case, what will happen? The Sun Direction, they can file a case against the Vijay. This is a small example. Okay. So it is not a real one. This is it's an example. So case study, this is a real case study which I have mentioned here. See this case study. This is a case study between Warner Brothers versus Nelson. So again, I'm telling you, this is just an example, not an original one. Just for understanding, I have mentioned this. So this is a real case study. An injection, that means court stay order. So what is the case study? This is a case study in between a Warner Brother versus Nelson. Warner Brothers are a producer and Nelson she is a heroine. Actually, she entered in a contract with the producers, Warner Brothers, till they complete their project of a filmmaking. She should not involve in any kind of she should not sign in any other new contract or new project. But what she has done, she signed in another contract of a movie. So what they have done, the producer filed a case suit against a heroine. So this is a real case. Okay. So that's all. The breach of contract is over. So these are all the types of breach of contract and its remedies. So suit for rescission means cancellation, suit for damages, suit for quantum merit, suit for specific performance, injection. Rescission means cancellation, the damages, quantum merit means as much as your specific performance means skilled related contract, and injection means preventing someone else to do or not do something. That is called injection. Okay. So thank you. Students, before reading any concept, try to read the examples first. Once you read the examples, definitely you could able to easily understand the concept of a law. Okay. So thank you very much. So if you like this video, please do subscribe and like. The link is posted. The other contract act link is posted in the description box. If you want, you can utilize for the study purpose. Thank you.